I went into a house, and it wasn't a house. It has big steps and a great big hall, but it hasn't got a garden. It isn't like a house at all. I went into a house, and it wasn't a house. It has a big garden and a great high wall, but it hasn't got a May tree. It isn't like a house at all. I went into a house, and it wasn't a house. Slow white petals from the May tree fall, but it hasn't got a blackbird. It isn't like a house at all. I went into a house, and I thought it was a house. I could hear from the May tree the blackbird call, but nobody listened to it. Nobody liked it. Nobody wanted it at all. Well, if we were to add another stanza to that sad poem by A.A. Milne from When We Were Young, it might be a verse about a building inspector tearing the house down because he alleges it is a nuisance. We're going to discuss a couple recent cases where that actually happened in the federal courts of appeals, and we'll discuss whether that was constitutional or whether a court can even say if it's constitutional. Today on Short Circuit, your podcast on the federal courts of appeals. I'm your host, Anthony Sandridge, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, January 28th, 2025. And yes, if you read the Short Circuit newsletter, you would notice last week that there were two cases from the Fourth Circuit and the Sixth Circuit where a house was alleged to be a nuisance and therefore is no longer a house anymore. To discuss this today are two IJ attorneys who very much are not nuisances themselves. We are happy to have them back on the show, and they are Christian Lansinger and Joe Gay. Welcome, gentlemen.
Nice to be back, Anthony.
Thank you for having me, Anthony. And I will say I'm a bit lower brow than you are, but I thought for sure that your poetry this week was going to be the Three Little Pigs and the Big Bad Wolf.
You know, I thought about that. It kind of didn't work. I also thought about the opening of Hitchhiker's Guide to the Galaxy, where they're going to tear his house down. But I actually did part of that recently on a different episode, and we don't want to be a one-trick pony here, so. I have done A.A. Milne before, though, so we'll have to broaden our horizons a little bit. Very much not lowbrow, I would say, though, to include the three little pigs. So before we get to these lowbrow building officials, well, one can argue, I guess. We'll check about that. I just have a couple announcements for our Short Circuit audience. One is, as you have heard in last couple episodes, and we've been advertising a newsletter, it is our 10th anniversary. And so we're having a 10th anniversary party. It is Thursday, April 3rd, 2025 in Washington, D.C. at the Studio Theater. If you're in the area and would like to come, we'd love to have you. Tickets are free, but they may sell out. So click the link in the show notes to RSVP. We got all kinds of big name folks coming that you can see. A couple retired judges, our friend Eugene Volek, a few other folks. So please feel free to click the link in the show notes and RSVP. Also, Bound by Oath. Many of you know about our legal history podcast, Bound by Oath, about the history of the Constitution and constitutional law. Season 3 is what we are on now. It's on property rights. Now, we had a number of episodes, and then we took kind of a mid-season break, but we're back now. John Ross is back with some amazing episodes. We just had one in January on SWAT takings, on very apropos of today's show, of where the police basically destroy your house when they're looking for a suspect with an innocent property owner, and whether that is covered by the takings clause. Very hot issue right now, so check that episode out, Bound by Oath. You can find it on any platform. We'll put a link in the show notes also to it. And then hot off the press, by the time this episode goes out, we should have out our latest Bound by Oath, which is about rental inspections and the Fourth Amendment. We talk about this famous case called Camara, which kind of is the bedrock of any inspection law these days. It's from 1967. And we interview the guy who argued the case. We interviewed him about Camara versus municipal court. So that'll be a really cool dive into some history that I don't even know has been written about much, let alone been on a podcast. So check that out. But right now we got this poor fellow in the Fourth Circuit who maybe was not the ideal plaintiff for a property rights case, although it seems like maybe his heart was in the right place, or he certainly could have been a little faster. So Christian, let's see what happened to him.
Yeah, so this house was in the city of Norfolk, which we discussed before recording. We were debating how to pronounce that. But this man was Danny Fox. He was an active duty serviceman with the Navy. He had bought a house in 2015, and due to him being in the service, he wasn't exactly the best at keeping up with the maintenance of his property. And during the times while he was spending a time on 2 different deployments, he had several notices come to his house about his property not being up to code. So it really started in the fall of 2016. He got deployed, and right around then, the city started sending notices after this initial inspection of his property that his property, as they put it, was, quote, unsafe or unfit for human habitation. They sent several rounds of notices. It's a little bit disputed factually how many times they sent notices out, but at least 2 to 3 rounds of notices that were mailed and posted onto his property in Norfolk while he was deployed elsewhere. Upon his return, there's no record evidence as to whether he actually saw the notice, but at least as he alleges, he maintained the property, made some repairs, and then got deployed again in April 2018. But unfortunately for Mr. Fox, the moment he got deployed again, a car ran into the side of his house, causing further damage. And so the city did a follow-up inspection. They took photographs. And as they put it, there were piles of debris falling and missing interior ceilings and walls, and that the property was generally in a state of disrepair. So they posted another notice. And this time, upon his return from his second deployment, Mr. Fox saw the notice. And he called the number that was on the notice, and they said he needs to make these repairs. He listed several different repairs in an email to the city that he planned to actually do. And the city responded that they needed more detail because they've already given him a lot of time, and that if they're going to give him a further extension of time, he needs to actually have a set completion date and some details as to how this is actually going to happen. From that point, the record doesn't show any more communication from Mr. Fox from the time of this last email to the point where they ultimately demolish his house. In June 2018, so this is now a couple months after he's come back from his second deployment, they post another notice saying that he has 30 days to repair his property or otherwise demolish it, or the city's going to go ahead and do it themselves. It also stated that he has a right to appeal for up to 14 days should he want to contest this nuisance determination. But again, as I mentioned, there was no record evidence that he did anything about this notice. So eventually, 6 months later, the city demolished his home, and he was fully aware of it in December 2018 that the city had demolished his home. But yet, for whatever reason, it took him 3 years between the time his home was demolished in 2018 to eventually December of 2021 to file this lawsuit. And he filed several claims, multiple under Section 1983, which, as short circuit listeners probably know, is the federal statute for various civil rights violations. That included a procedural due process claim, a Fourth Amendment claim, which actually referenced the Camara case, I believe, dealing with inspections. It wasn't maybe necessarily the right case here, but he also alleged a takings claim under the Section 1983, and then he alleged a state claim for takings under what the state inverse condemnation process, which all that really means is the takings clause says your property can't be taken for public use without just compensation. So inverse condemnation is just a process where the plaintiff in that instance is actually the property owner trying to allege that their property was taken and that therefore they didn't get compensation. So anyways, he makes all of these claims. And what's unique about Virginia is that Virginia is one of the many states in post-Kelo, which Kelo, again, an IJ case that said that it was Kelo was an IJ case that basically said that there are certain goals of redevelopment and giving property to private parties that would be considered a public use. And many states after that case reformed both their constitutions and their statutes to provide greater protection for property rights. Virginia was one of those states. And they statutorily defined what is a public use, one of those being that the property is being taken for the elimination of blight. So I bring all of that to say that the state claim's a little bit unique in this context, and it's important because when he gets to the district court ultimately grants the city's motion for summary judgment. And part of the reason they do that is all of the federal claims, the Fourth Amendment claim, the due process claim, and the takings claim under Section 1983 are all time barred. He waited 3 years to assert his rights. And as the court said, usually when it comes to a Section 1983 claim, you generally have 2 years to assert your claims. That comes from state law. That is a 2-year statute of limitations. And he waited 3 years. So the only claim he had to rely on was that state takings claim, that state inverse condemnation claim. And what the court held is that the facts don't really matter. There's no genuine dispute of material fact here because either the property was a nuisance, and in that case, Virginia law is very clear on this point, which is that when the government does nuisance abatement, they don't owe compensation. So either the property is a nuisance and therefore he doesn't get compensation, he doesn't really have a right to a remedy, or the property is not a nuisance, and oddly enough, because of the way Virginia law is written, then that's not a taking either, because if the property is not a nuisance, then in that case, the government had no public use at all, no public purpose. And as the statute's written, one of the requirements to file an inverse condemnation claim in the state of Virginia is that the government's actually is pursuing this taking in relation to some public use or public purpose. So the court said there is no takings claim here under the Virginia Constitution. That's not to say that Mr. Fox had no remedy at all here. He could have pursued, as the court held, he could have pursued a due process claim, or he could have actually taken that 14-day process to appeal and contest this nuisance determination. But here he slept on his rights, and those alternative remedies weren't available. So when it comes to a takings claim, he really just chose the wrong remedy, or in this case, was left with the improper constitutional remedy here. So this was appealed to the Fourth Circuit, and the Fourth Circuit upheld the decision for largely the same reasons. They said that whether the fact finder was to determine whether this house ultimately was a nuisance or was not a nuisance doesn't matter. There's no takings claim here. And they again repeated, and I'm quoting from the opinion, they said regarding the alternative remedies, so to the extent Fox now lacks a remedy, it is not because Virginia law is harsh, it's because he failed to timely pursue the available remedies. So this was a bit of a sad case in which an individual may have had some kind of a constitutional claim. It seems like there's something wrong with the fact that his house was just declared a nuisance, and we don't really have much in the record as to indicate why it was declared a nuisance and whether it was actually unsafe. But here, because he slept on his rights regarding certain legal avenues to seek a remedy, all I had to fall back on was this inverse condemnation claim, which part of that requirement is that the government was pursuing some public use. So anyways, that's a little bit about his case, and I'm curious, Joe, if you have any thoughts, or Anthony, if you have any thoughts.
Yeah, I mean, when I was reading this, I almost felt like the court's reasoning, to me, it almost felt a little bit too clever by half. Like, I mean, not to impugn any of the judges here, but I almost kind of in my head, I heard kind of an evil cackle where somebody realized like, haha, if it's a nuisance, you don't have a remedy. But if it's not a nuisance, you also don't have a remedy. And I was a little just frustrated by that directionally, because that reasoning is based on, as you mentioned, these post-Kelo reforms that were basically trying to be more protective to property owners by narrowing the scope of what's considered a public use. And what the courts are doing are essentially taking that reform to help property owners, and they're kind of flipping it around and then using it to deprive this property owner of a remedy here for what is, I think, I don't know about the ultimate merits, but certainly is a pretty significant deprivation of property rights. And I don't know that super hyper literal reading of Virginia's constitutional right here was necessarily the right one. They cited to some Virginia case law that talks about how there has to be a public use for there to be an inverse condemnation. But that case law is really talking about situations involving like unauthorized actions by government officials or negligence. I think the seminal case that they cited here was one that actually happened nearby where we are in Arlington, where a failure to properly maintain and operate the sewage system led to a backup in a grocery store, and the grocery store's insurer sued about this. And the court said, I think quite reasonably, it's not a taking to just be careless or to be negligent. You really need some sort of. They talked about public use, but what they were really talking about was this has to be purposeful conduct. And so I think the court took some of that language and applied it a bit more broadly than the case law necessarily demands. Now, maybe that's the correct extension of the case law, but I don't think they really grappled with the fact that they are actually broadening this existing case law about when when Virginia's takings clause applies, and applying it to a somewhat new situation without really grappling with the fact that it does seem to be a bit of a new situation. And I would just point also to the language of Section 11, which says that the General Assembly shall pass no law where private property, the right to which is fundamental, shall be damaged or taken except for public use. And what the plaintiff here alleges, that's a violation of that. It violates Section 11 of the Virginia Constitution because under his theory, they damaged his property and it wasn't for a public use. And so maybe you could quibble about whether that triggers the just compensation requirement, but I think that there is a serious constitutional question here that maybe is a little bit weightier to me than the panel really reckoned with.
Well, one thing that's not totally clear to me, although I think I know the answer, is that the inverse condemnation statute that Virginia has, that is kind of a statutory claim to effectuate the state takings claim. I think, or maybe it's like a statutory claim separate from the state constitution, or maybe it usually doesn't matter. But what I think maybe the court is saying is that the inverse condemnation statute is not a way to enforce the state constitution's public use clause. So the opposite being, if it's a private use or a non-public use, whatever it is, tearing down this house, that there's the legislature just hasn't created a remedy. They've created a remedy for all these public use stuff, but not for getting compensation. And so whatever your ultimate remedy is, like whether it's the save your home, which is a typical public use clause case, like in Kelo, or it's maybe to get compensation because it's too late. That's just not the avenue you took. I mean, maybe there's another way you can raise the public use clause after a house is destroyed in Virginia. I mean, they say due process. I wonder if that's kind of they're just using that as a catch-all way. Of course, they're talking about the U.S. Constitution too. So there's some fine-grained details that could get worked out there, and maybe the court just didn't care about some of that because, all these other clauses that could have helped where the statute was blown, the statute of limitations. I actually so the best person to ask about this would be our friend Robert Thomas, who's a longtime property rights lawyer and has been on Bound by Oath. You guys can listen to those episodes if you want to look him up. And he has his inverse condemnation blog, and I see he has blogged about this case. We'll put a link in the show notes to it, but he didn't dig down in this particular issue, and I'm wondering if maybe that's because it's kind of true that you just don't have a public use clause claim there. He also, though, mentioned something else that's right at the end of the case where the property owner also brought up this issue that really they were trying to do this for redevelopment in the area, but it's really kind of hazy pleading. There's not a lot of argument there, and so the court's just like, we're just not going to do anything with that part. I mean, I don't even know what claim he would attach that to. Maybe it's not even useful to him, but the court just wasn't interested in that, it seems.
Yeah. I think the takeaway might be a little bit, and I've seen that blog that Professor Thomas wrote, and I see at the end, I'm quoting from it, he said, take that last one being the alternative due process remedy. Take that last one and keep it in your file for future development. And I think the takeaway is really maybe just file your claim as timely as you can, pursue both a due process claim and some kind of a claim under the takings clause, especially in these, if you're pursuing it under a state constitution where maybe, as Joe was pointing out, there's some language that suggests maybe there's something else to it. I will say, I think somewhere in the opinion, they talk about a separate allegation that Article 1, Section 11 of the Virginia Constitution says property rights are fundamental and therefore subject to strict scrutiny. And the court kind of tossed that one aside as already being determined as that's not what it says. I mean, I'm curious what it says. The General Assembly shall not pass a law. I don't know how strictly that's read and if that would really apply here where we're talking about an inspector declaring a nuisance, if that would really trigger the application of the takings clause here. And I can also understand that at least in terms of the right that's being violated, we perceive the takings clause as something for when there's an otherwise lawful taking, we want to ensure there's just compensation. And yet maybe there's something else, maybe it's the due process clause, that says when that taking is utterly unlawful, that there's no really, compensation's not the exact remedy there for any damage to the property, but really it's a separate harm to your natural property right and your lack of process altogether. It just, you cabin this case in one camp or the other. There's a potential, maybe there's both. Maybe there's a violation of both due process and some kind of violation of this expanded takings clause, because as Joe points out, the whole point of these post-Kelo amendments to Virginia law, both the Constitution and the statutes, was not to actually shrink the ability to raise a takings claim. So it seems like there's something here. But it's kind of left open-ended. If you have some kind of a pretextual issue or anything really regarding whether the government is actually enacting a public use, it's not really clear where your remedy is. And so maybe it's just a free fire, contested at the administrative hearing, and then raise due process and taking claims afterwards, see where you end up. But I think take that last one and keep it in your file for future deployment's probably the right place to be right now.
Very well said. Well, one case where the plaintiffs deployed their arguments a little bit better, it seems, was this case in the Sixth Circuit, where they at least have a fighting chance now at trial. So, Joe, tell us what happened with this opinion by Judge Sutton.
Sure. So this decision, this case is called McIntosh v. City of Madisonville. And as you mentioned, it's authored by Chief Judge Sutton, joined by Judges Bush and Murphy. And Judge Murphy also has an interesting concurring opinion. So I'll turn to that in a moment after talking about the majority opinion. But it's an interesting concurrence to separately address. But starting with the opinion of the court, the plaintiffs in the case are Michael and Rebecca McIntosh, who own a very small, basically 9-lot mobile home park. And they rent out the mobile homes in the park. They've done so for, it seems like, several decades. But starting in the fall of 2020, they apparently have some sort of issue with one of their tenants who makes a complaint about the condition of the mobile home. It is inspected by a code enforcement officer, and then subsequently inspected by a building inspector from the city of Madisonville. Their descriptions, not promising for the McIntoshes. Things like organic growth, vegetative growth on the walls, a floor that is soft in some areas, unstable 2x4s supporting the ceiling, all things that maybe not good things for where you might want to live. Now those are the city's characterizations, so I think the plaintiff would dispute that to some degree. In fact, I took a quick peek at some of the summary judgment part of that decision, and he claimed that some of the damage at least was actually caused by the tenant, and that she may have even sprayed water inside of the house to make it look worse than it was. So there may have been a little bit of a factual dispute there, although I don't think it was really disputed that there were at least some problems with the unit, whether caused by the tenant or elsewhere, that had to be fixed. So anyway, so after seeing these issues, the city sends a letter saying basically, hey, your property is in violation of the International Property Maintenance Code, which is basically a building code that's widely used across the U.S. And they tell them the Macintoshes that they have 30 days to submit a plan for fixing these problems. They don't really tell him what the problems are, but whatever they are, he has 30 days to submit a plan to fix them. And then they also put a notice on the unit itself saying, warning, condemned, do not enter. Mr. Macintosh, he responds to the letter. He sends his own letter disputing the accusations that the building is unsafe. And he also reaches out and gets a copy of the maintenance code, presumably so he can look at that and see what he needs to do to fix the unit. So far, so good. I think everybody agrees that this is what has happened up to that point. As the opinion then notes, there is a diverging story about what happens next, which makes me kind of, just as an aside, wonder, well, why was summary judgment granted here if you have diametrically opposed accounts of what happened here? But setting that aside. So the Macintoshes' story is that they're reaching out to the code enforcement officer several times to figure out what they need to do to fix the home. The officers basically won't answer their question, and he's pointing the finger at the building inspector. They reach out to the building inspector, but they can't reach him. And the employee basically says, "Well, if you don't like our decision, just sue us." He asks, "How do I appeal their determination?" They say, "Actually, we don't have a board to appeal to." And they just turn off the power to the unit too, which makes it even harder for him to fix the unit because he doesn't have power there. He then claims that he actually goes in and he fixes the source of all the problems that they saw. He says that there was a leaking valve on a water heater, and that he fixes that, and then he's working on fixing the other, I guess, presumably the damage that caused. He's in the process of fixing that. And he's talking to city officials, and they say basically, we don't care what your letter said. I'm going to tear that house down. And again, his view is that they never come back and look at the unit again until it's time to tear it down. The city tells a very different story. They say basically he reached out and he got a copy of the property maintenance code, but he never did anything after that. And that they had offered to work with him to figure out how to remedy the issues, but that he rejected that offer as well. And they also dispute that they received some of his communications about having repaired the property. And they say that they actually did re-inspect the property and that all they saw were cosmetic repairs that didn't really fix the underlying issues that they had noticed. So essentially, right down to the date, 30 days after that initial notice that the property was condemned, and I think add maybe 1 or 2 days because it would have fallen on a weekend, but essentially right on schedule, they show up. You know, it's almost like the scene from the beginning of Hitchhiker's Guide to the Galaxy. They're there, they got the equipment, and he's calling everybody. He's calling the city attorney, he's calling other city officials, trying to figure out how to get them not to knock his house down.
He doesn't lay down in front of the bulldozer, though. It seems that's maybe the one thing he didn't do.
But do you have any idea what damage that would cause to the bulldozer? Absolutely none.
Very good.
So anyways, so they demolish it. So he sues, and he sues, like our friend in Norfolk. He brings a procedural due process claim, a substantive due process claim. I think I saw that he also brought a takings claim, but he seems not to have pursued that on appeal. I'm not sure what happened to that, as well as a state trespass law claim. And he actually brings the case in state court, and for whatever reason, the city removes to federal court. And then after discovery, the district court grants summary judgment in the city's favor. And I did, when I took a quick look at the summary judgment order, I was actually surprised. It was largely based on another district court decision that involved basically the same people doing the same thing to somebody else. Except in that one, it involved a car wash, and the owner had been neglecting that, I guess, because he was caring for a sick family member. And in that case, the court had said, well, even if you didn't receive any notice at all, I think there's probably not a procedural due process claim here. So that court had granted.
Wow.
They said there's no evidence that the owner there even received a letter or notice about the pending demolition. But they said, well, you put a notice on the property, so that's probably sufficient. A little kind of wild, but given that existing persuasive authority, I think it was probably a long shot for this plaintiff at the trial court level, at least. And summary judgment was granted in favor of the city on his procedural due process claims and his substantive due process claim. And so the plaintiff then appeals to the Sixth Circuit. And fortunately for him, there was no issue with timeliness. So he was able to actually really focus on especially this procedural due process claim that our friend in Norfolk wasn't able to pursue. And so the opinion by Judge Sutton, it really focuses on this procedural due process issue, which basically under Supreme Court and Sixth Circuit precedent in the context of a demolition basically says you have to have notice and you have to have the opportunity to be heard before the property is actually torn down, not afterwards, which would be a little bit too late. Now, for notice, the existing standard here is, and it must be, quote, reasonably calculated under all of the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. And that comes from a case called Mullane v. Central Hanover Bank and Trust Company from 1950, a Supreme Court decision. And I'll just make a brief aside here. I took a look at that decision too, because I thought, well, what's going on there? And that was actually a case about, it involved something essentially relieving a trustee of certain obligations, discharging them of their trustee obligations. And you had a lot of beneficiaries of the trust, some were out of state. So it was really hard to actually give notice to all of them. The state was doing this by doing publication. And the court said, well, ordinarily for this kind of posture, you would really want personal service of written notice, but it wasn't really practical in a situation like that. And it said, and anyways, you have all of these beneficiaries. They're all similarly situated. And so as long as you are assured that most of them get noticed, that's going to safeguard the rights for everybody. So we're going to kind of sign off on this kind of laxer view of what kind of notice you have to give to these parties under the unique circumstances of this case. And I just bring that up because that was in 1950, and it was a very context specific idea that it was not really practical to give personal notice to a large number of potentially out of state people who might be impacted by a decision about a trust. Has now been over 75 years held that, all right, maybe one person's property that is actually getting torn down. Yeah. Maybe you don't actually need to tell that person. It's at least debatable. You don't maybe even need to tell that person that you're about to knock their property down. And so I think there is maybe a slow drift here where some of our basic protections have bit by bit, decision by decision, situation by situation, really been chipped away without us kind of like boiling the frog. You haven't really noticed over time how far we've gotten from what you might have expected.
And I don't know if that precedent was involved, but one of the longest cases we've had at IJ was this case called Brody in the 2000s. It was litigated in the Second Circuit about our client not getting notice about a procedure that then led to his property being destroyed and redevelopment and eminent domain and all that. But it was primarily about this notice issue, and it went for years and years, up and down before in the settlement, the city eventually officially apologized to our client for what they had done to him. So yeah, I wasn't part of that case, and I don't remember the specifics and if this precedent was involved, but I think that very much is probably part of this boiling of the frog that you're talking about.
Yeah, and I know I've definitely seen that in other IJ cases where fines, for example, have been upheld, even if it's not clear that the person received notice or maybe their right to appeal fines or something like that. But the courts have become very lackadaisical about actual notice based on this standard that I think has really expanded over the past few decades. But that's all an aside. So under the facts of this case, the panel says, well, here the notice requirement is satisfied. After all, it's undisputed that he actually did receive the letter about the condemnation, and he did begin actually trying to repair his home. So there's no dispute here that he actually knew that something was afoot. Doctrinally, the trickier question is about whether the letter actually said what it needed to say to provide the notice. The first problem was it didn't actually identify the specific problems with the home. So, I think that's problematic because if you're trying to repair your home to fix the problems, or you're trying to decide whether to appeal or to make a repair plan, it's all kind of a useless exercise if you don't actually know what the problems are that the city has found with your property. But the court kind of waves that away and says, well, he at least had notice, so he kind of knew how to act at this point, and we're not going to look any deeper into that. So I won't go into detail with my problems there. I will note that I have a little bit of a quibble there because I do think there actually were some problems with saying that somewhere in this, thousands of words of property maintenance code, you have some violations, but we're not going to tell you where in those, dozens and dozens of pages your actual violation is. I do have some quibbles with that. But the second problem with the notice was it didn't tell him that he had a right to a hearing or what he should do next. But the problem there was this Supreme Court decision called City of West Covina v. Perkins from 1999, where basically the Supreme Court said, if there's publicly available statutes or case law that you could look to figure out what you do next, then the notice doesn't actually have to tell you that you have a right to appeal or how to appeal or anything like that. So here the court says, all the McIntoshes have to do is, open up the municipal ordinances, find Title 15, skim through to Chapter 150, then find subsection 13, and then at subsection C, they would see, all they have to do is, appeal to the to the local board of appeals. So court says, okay, for notice, no problem here. So it then turns to the second issue, which is the opportunity to be heard. And here things go a little bit better for the property owners because the court says, citing Sixth Circuit precedent, there has to be some kind of hearing before the state destroys the property, or at least some kind of opportunity for a hearing. And the municipal code said there was a right to appeal the building inspector's decision to the local appeals board. But when Mr. McIntosh called up and said, how do I appeal to this board? The city employee said, well, there is no board. Okay. And then in the deposition of the building inspector, they asked him about that. And he says, yeah, there is no local board. They quote, didn't feel it was necessary to have a board to which you could appeal these decisions to demolish your home.
Even though it's in the code.
Yeah. Their view was that, well, you can have a conversation with the city about necessary repairs. There's an informal procedure here. You can go to the city attorney who will act as an arbiter of the dispute.
I'm sure he's very neutral.
Yeah, exactly. So we have all these informal mechanisms that you can use to resolve our dispute. But the Sixth Circuit rejects that. And just sort of assuming that even if this procedure might be adequate in the abstract, which I highly doubt it. But even assuming, it wasn't written down anywhere. It just exists in the minds of city officials. And so the quibbles that I had with notice earlier, that was at least you could look to a public code and figure out what you need to do to appeal. But then you're back to your same notice problem. If it only exists in the minds of city officials, that is not, even under West Covina, the Supreme Court precedent, that's not going to pass muster. And so basically, the court says this kind of procedure, it's not adequate. They didn't have any notice of it. When they asked about how to resolve it, the city employees didn't tell them about it. And so based on all of this, the court concludes that a reasonable jury could find that the procedure in the municipal code was illusory because there was no board, and that the informal policy either did not exist or was never provided to the property owners. And so it reverses the district court's grant of summary judgment in the city's favor, and that claim is going to go back down to the trial court. The plaintiffs here, they did not move for summary judgment on their own end. So I guess it presumably is teed up for trial on that issue. The court also briefly addresses their substantive due process claim. The McIntoshes had said that they had a substantive due process right to be free from conscious shocking actions. I think knocking down a home, I think strikes me maybe is at least within the ballpark of that, but under Sixth Circuit precedent, that claim didn't seem like it was really going to go anywhere. And so the court kind of dismisses that out of hand because it's basically says, even if they got it wrong, they're just doing their municipal police power thing. And so I'm not going to open the door to viewing this as shocking the conscious. So the court just kind of waves that away. And then they also had a trespass claim that the trial court had dismissed, basically saying, I'm not going to exercise jurisdiction over this last remaining state law claim. And the court says, well, looks like that might be back in too, because now your procedural due process claim is live. So that's a decision. So I think a happy outcome for the property owners. And now I do want to turn briefly to Judge Murphy's concurrence, which I think is really interesting. And that concurrence starts, this case shows that an evolving standards approach to constitutional interpretation can destroy rights just as much as it can create them. So I start reading this and I'm thinking, all right, this is going to just be some sort of attack on a whole bunch of more modern procedural protections that we have in place. But while I do disagree a little bit with how he framed this issue and that underlying thesis, I think I actually agree with the bottom line that Judge Murphy is drawing here, which is that as originally understood, and he's talking to, I think, both early common law authorities, due process of law as originally understood, it had robust protections for a narrowly considered set of historic property rights. And the due process clause basically was incorporating these baseline common law procedural protections for those property rights. And these common law baseline protections presumptively put a neutral court in place in between the government and the deprivation of our property rights. And viewing it from that angle, from this historical angle, from this common law angle, this case really would have been an easy decision, because basically what happened is a building inspector wrote down the word condemned, waited 30 days, and then tore down the building. And historically, that's just something that executive officials aren't allowed to do unilaterally without the involvement of the court. And he cites some historical authorities saying that this is a determination that a court has to make. And so if you follow that historical rule, this really just is an easy case for a procedural due process violations. And then how we got here, that what should be a 1 paragraph, maybe a 2 paragraph decision is instead 4 pages or so of analysis by Judge Sutton. He points to the expansion of due process rights in the 1970s to call the so-called new property interest in things like welfare payments in cases like Goldberg v. Kelly and Matthews v. Eldridge, which give us this modern balancing test that we are often seeing in cases like this. And if you expanded procedural due process protections to all of this new property, protecting all of that new property, it would be so burdensome that then you inevitably have to water down our rights, our procedural due process rights. Otherwise, the whole system would get bogged down. So it's sort of the cost of expanding the protections is to water down what those protections actually mean. And I'm not really sure I exactly agree with that causal thesis. I reserve judgment a little bit just as a matter of causality. Although, as I mentioned earlier with Mullane, I think some of this stuff predates. I think some of this predates Goldberg and Matthews. So I kind of wonder if without those cases, we just end up in the worst of both worlds, where we don't have protection for kind of administrative executive decisions, and we still have a degradation of our traditional due process protections. But I think the bottom line is basically right. I think that it would be a better approach to say that when you have something like what we have here, where you have this, you're demolishing property, a building, you're going onto somebody's land, which is a trespass. You're knocking down their home, which is a trespass. You're demolishing their home, which is an important piece of property. That is something that should just inherently have a judge standing between the citizen and random Kentucky building inspectors, all due respect. And so, I think I really, despite my quibbles with maybe how it was framed, I think I really agree with Judge Murphy's bottom line, which is I think we need to reevaluate when and why we're allowing executive officials and local officials to just go around demolishing homes without any judicial oversight.
Christian?
Well, I'd just say it seems like some of concurrence may be more directed to what attorneys on this podcast, I'm sure, have brought up, which is the Matthews test. Considering the burden on the government and the government's interest when you're evaluating whether someone's constitutional rights violated to that level, where you're just saying, all right, whose interest matters more? It can be dangerous when it comes to somebody's home. I know in this case, we're talking about a landlord owning several mobile homes, but either way, at least it opens the door for a watering down, as the Judge Murphy put it, of various property rights that we hold dear. But at the same time, even under Matthews, you'd like to think that a house would be seen, when we're considering the private interest, the property interest, a house would be seen paramount of the different interests. I do read this case, though, and I'm also, apart from the procedural due process issues, I also think when you take this case along with the case out of the Fourth Circuit, the concern of relying on due process as kind of this one and only way to challenge something like this with a nuisance determination. We saw the substantive due process claim and whether it shocks the conscience. And so all it really takes is an expansion of nuisance law to say that, well, what the government doesn't like and thinks can pose any kind of at least decent enough risk to public health and safety, well, then we're going to go ahead and just call it a nuisance and demolish it. We already know, at least in the federal takings clause context, that I think it's the Lucas case, they talk about how takings claims are limited by these same background principles of the state's law of property and nuisance. And in the dissent in that case, Judge Blackmun talks about nuisance being a, quote, impenetrable jungle. And so there's kind of a broader issue here, which is if we're just relying entirely, even if let's just say there's adequate process, and we can actually kind of discuss in front of a neutral arbiter whether something's a nuisance or not, how we actually analyze that, and make sure that it's taken seriously when it comes to something as important as someone's home. But that was just something I kind of saw when I was thinking about how these cases kind of come together.
Well, that's something lurking in the background, isn't it, in both cases, is what actually is a nuisance and what is a constitutional enforcement action if there is a nuisance on behalf of the city. I mean, there's other case law out there where you actually have a city council pass a resolution saying this is a nuisance, and that is really hard to fight back against, about whether, and then there's this doctrines about there's public nuisances and private nuisances. And so public nuisances, city can kind of do whatever it wants because that's impacting other property owners, and a private nuisance is kind of a little bit different, but it's all, as you said, Christian, a thicket that's hard to cut through. So that here, the city didn't have those on its side because it was just one building inspector saying it's a nuisance. But even there, when push comes to shove, if this becomes an issue at trial, there unfortunately is going to be some deference to the city official about what's a nuisance. I mean, in both of these cases, I started thinking, okay, say it really is a nuisance, what in a common parlance we would call a nuisance. Is the remedy to tear it down? I mean, maybe in some cases it is. Like the first property, right? It had a car that hit into it. Maybe it had a big hole in its side. Maybe it was about to fall down. There's a property right next to it. Like you could argue there if the owner never did anything, well, maybe there's a property remedy of tearing it down. But if it's just a mobile home sitting there and no one's living there, why do you need to tear it down? It's just no one's living there. I mean, maybe you could say it's an attractive nuisance. Some child is going to go play in and get mold or something, I suppose. One other, it's a completely different issue. One other small point is I am just amazed about how they don't have a board that sits to review these issues. And when I read that, I thought, this must be some tiny little town, of like 150 people, and this just doesn't come up. I looked it up. It's a town of like city, 20,000 people. And they've never had their board sit. I think the guy must have either was lying, because that property disputes in a city of that size come up all the time, or they really just have like a good old boys kind of, put the screws to people network that is able to not have to do that. I mean, we litigated a case in a nearby city in Indiana that was only about 10,000 people, and like it wasn't a great city. Its government was totally awful, but their board would sit like it was a normal, regular thing. The city attorney knew how to run the board, and yet they don't even do it here. What is going on in that city hall?
Yeah, and as I mentioned, there was that other summary judgment decision where they had done the same thing to another car wash owner, the same building inspector, the same lack of an appeal board. And these are just the people who chose to fight back. So I think these cases are really just the tip of the iceberg of what is really just a probably a nationwide problem with cities, I think, responding to the housing crisis from 2008, 2009, and feeling, I think, pressure to do something about some distressed properties, but cutting a lot of corners to do it in very problematic ways.
Well, that's kind of what the Constitution is there for, is to not allow city officials to cut corners. But when you give them precedence like we've talked about today, they're going to boil that frog to bring everything together and to tear the house down. Well, thank you both for coming on and tearing these issues down. I think you did a great job with that. Everyone should go check out Bound by Oath, sign up for our anniversary party if you're in the area, all the other things we've talked about. And in the meantime, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast networks. And remember to get engaged.